In 2009, the United States Supreme Court ruled unanimously in favor of the defendant in the case Stop the Beach Renourishment v. Florida Department of Environmental Protection. Before the case was decided, I wrote the following short essay for a university course on constitutional law, arguing in favor of the plaintiff. It should be noted that the Florida Department of Environmental Protection's actions restoring eroded beaches actually enhance the property value of the owner's beachfront property. The essay reads thus. It is possible for the U.S. Supreme Court to have jurisdiction over Florida's private beachfront takings case because the issue under debate in this case is the consistency of state law with the provisions of the U.S. federal Constitution, and also because the plaintiff contested the decision of a state Supreme Court, which means that the dispute may be appealed to the U.S. Supreme Court. This case should be decided in favor of the plaintiff, the Florida property owners. The Fifth Amendment of the U.S. Constitution states that private property, quote, shall not be taken for public use without just compensation, end quote. The Florida property has rightfully and legitimately been deemed necessary for the state to condemn, but as long as the decision of the state Supreme Court is permitted to stand by the U.S. Supreme Court, the plaintiffs will not have been justly compensated for the decline in the value of their homes that has resulted from their loss of control over the access to and use of that beachfront property. In the 6-3 decision of Lucas v. South Carolina Coastal Council, in the opinion of the majority, Justice Antonin Scalia wrote that, according to the majority's interpretation of the Fifth Amendment, compensation is required in the event that the regulation, quote, compels the owner to suffer a physical invasion of its property, end quote. To convert the plaintiff's property into a public beach, which could also be used by vendors to sell food, amounts to a physical invasion because it would make it possible and likely that areas near the plaintiff's homes could frequently become mobbed with crowds of people, which would cause the disturbance of the local property owners. Furthermore, the 14th Amendment states that no state shall, quote, deprive any person of life, liberty, or property without due process of law, end quote. In the 1897 decision of Chicago, Burlington, and Quincy Railroad Company v. Chicago, Justice John Marshall Harlan wrote the opinion of the 7-1 majority, quote, since the adoption of the 14th Amendment, compensation for private property taken for public use constitutes an essential element in due process of law, and that without such compensation in the appropriation of private property to public uses, no matter under what form of procedure it is taken, would violate the provisions of the federal Constitution, end quote. Justice Scalia also wrote in the Lucas decision that, quote, land use regulation does not affect a taking if it substantially advances legitimate state interests, end quote. Issues that will be at contention in this case include whether condemnation for the purposes of mitigating potential damage to property along the coastline constitutes a substantial advancement of legitimate state interest, and also whether the benefits of the protection against damage to property by hurricanes, which has been conferred upon the owners by the state, constitutes by its own merit just compensation for the owner's decline of property value resulting from loss of control over access to the newly appropriated land.